aside from other comments, Mr. Robinson is asking Mr. Batey about his background and what is completed in football, track, etc., in college, and I objected. I said, Your Honor, I object. We had a discussion about this, and I think Your Honor ruled this is beyond the scope. And Your Honor said at that time, right. I mean, he can give basic information, but beyond that, it is not relevant. So just keep it to the basic information. Mr. Robinson picked back up where he left off. And the next page, 1769, after two or three more questions, I stand up and say, Your Honor, how many times? And the court says, Mr. Robinson, you have to just keep to the basic information. And we go on. So, Your Honor ruled on it and granted. Objected, and Your Honor ruled on it again, but I think that is the one as far as reiterating that basic information. Not that I don't mean any disrespect, that his parent, that his father died when he was young, that he was one of 13 children, that he has now fathered a child while on bond in this case. None of those things would be relevant to submit or should be addressed at any time for opening statement, testimony, or anything, as Your Honor has previously ruled, that are irrelevant and outside the scope of what needs to be presented to the jury.
All right. Okay. Now, for the defense to respond to any and all of the motions in limine, feel free.
Your Honor, I don't have the luxury of having them here in front of me today, so...
Well, you want my copies?
Your Honor, with regard to...
Did they give them? Okay.
With regard to number one, referencing Mr. Batey as Cory Batey or Mr. Batey, that's fine, Your Honor. That's not an issue. With regard to number two, regarding prior bad acts and having a jury, introduction of prior bad acts, and having a jury out hearing before that being addressed in testimony, we agree to that, Your Honor. Number three, I believe you granted that one, Your Honor.
I do. I specifically recall that, and it's an issue that comes up all the time. It's a hall issue, self-serving statements. Yes, I granted.
Yes, I think so. So I understand that, Your Honor. And if there were a question, we would, or an issue, we would ask for a jury out.
Right.
Going there.
All right.
Number four, Your Honor, and I can bring it up now or later with regard to the 412. Your Honor, we did have an extensive hearing on the 412 issue, and I believe what we want to do is ask Your Honor if we can adopt the arguments made by both sides regarding the 412 issue and make them a part of this record to preserve it, because I know Your Honor.
That's fine. I mean, if the appellate, if it gets to the appellate court, I would hope that they would allow that adoption. I would think so.
Well, please, I think we ought to reflect on it when there was a new indictment. We adopted all the motions before the previous ruling.
Right.
In the other case to apply here, obviously. I think that's already been done. If it hasn't, we'll do it a second time.
I think he's doing it out of an abundance of caution, so I understand that.
So, and I think all the parties agree on that, so we would like to just have that ruling for the record. And I believe on number 5, Your Honor.
Your Honor, what's the
Okay, what's the problem here?
Yes, use the restroom. No.
Whoa, wait a minute.
No, he said he
No,
couldn't.
he's upset, Your Honor. It looked like he was,
Okay, well, he can't just walk out of the courtroom like that.
I didn't know what was. Would Your Honor like for me to go outside?
Yes, I need him in here. You don't just walk out of the courtroom.
John take him to the restroom, Judge. He's sick.
He's ill?
Yes.
Okay. All right, I'll take 5 or 10 minutes.
All right. Been a brief recess.
Yeah, it's already been turned on.
What is it?